to object to portions of it but still allow the rest of it to come in. Okay, the use of written depositions at the hearing, Rule 1613B3. You can use a written transcript of a deposition as first-hand evidence in an arbitration proceeding, even though the witness is not unavailable within the meaning of the usual rules on depositions, so long as the deposition was taken in the manner provided by law or by stipulation and within the appropriate discovery cutoff period. All you have to do is give notice of your intention to use the transcript to the other party within 20 days prior to the time of the hearing, and that deposition transcript can be admissible. If the other party who receives your notice doesn't want the transcript in, that party must subpoena the witness to show up. This gets back to the subpoena. If the witness is subpoenaed, then the arbitrator gets to decide whether to exclude the transcript or whether to include the transcript but allow further cross-examination.
It's interesting now to distinguish between these three sections. The first one was dealt with medical reports, police report, and so on, 1613B1. Just by following the section, those documents go into evidence. B2, the other expert witnesses, other witnesses' statements, and so on, they don't go in automatically, but by the opponent who doesn't want them in can give you the notice at least 10 days, and then you have to produce the witness. Under the deposition, which is 1613B3, it's just the reverse. The deposition goes in as long as it was taken properly, and then it's up to the opponent who doesn't want it in who has to then subpoena the witness. So you have to distinguish between those three sections.
Okay, now you as the trial lawyer decides whether or not you want to try to introduce the transcript in this fashion, and by and large the reasons for doing so are identical to the reasons for using the witness statement, the written witness statement, the cost versus persuasiveness, the desirability of the witness. The important thing to consider here, though, is that you've got a much broader range of testimony. You've got actual examination, and you can look at your deposition transcripts dispassionately and determine whether this is the kind of testimony that ought to be presented or whether you want to polish it up. It is certainly a good reason for making sure that when you took the deposition at the outset, that you did a good job. It's different from trial work. At a trial, if you're anticipating trying the case, your depositions shouldn't be, but they can be sloppier than these arbitration proceedings. It's not likely in a trial that your deposition transcript is going to be used. In an arbitration proceeding, it's much more likely. On the other side of the coin, if you get the notice from your opposing party and you have to decide whether you'll subpoena the witness or not, one consideration that is different in this situation than on the written statements is that you've already cross-examined the witness. You've had your shot at cross-examining. So again, you better have done a good job during the deposition itself, and if you have, then you can save a lot of time and money in allowing this to come in. Also keep in mind that you must subpoena the witness if you don't want the transcript used. It's not simply a notice. Unless it's a party, then you can notice the party. A further word on deposition transcripts. I say this now as an arbitrator, and this isn't just a word, it's a plea. Please designate the portions of the deposition transcripts that you intend the arbitrator to focus on. What happens in these things is the parties come in with a whole book, and they expect you to read it. The arbitrator may be required to do so, but I don't think that's a fair way of doing it, and I don't think you're likely going to get the focus that you're entitled to.
I think that's really the most crucial point. Aside from upsetting the arbitrator, I suppose that might be important if you give him a stack of depositions to read. The fact of the matter is that you probably want the arbitrator to read the deposition because of 2 or 3 or 4 questions and answers that are in this whole book. If you just give them the whole book, when they get to the parts you're really interested in reading, they just may have semi-dozed off and go right through and miss the crucial points you wanted them to read. So why not just give them the page and line numbers? The other side can give their designation of additional questions and answers they want read. Then the arbitrator focuses right in on the things that you are interested in having the arbitrator read.
And I think the best practice, at least the most ethical practice in this area to me, is that you ought to designate the portions at the same time you advise the other side that you intend to introduce the transcript, so that the other side can focus in on exactly why you're doing this, and rather than willy-nilly object, at least be able to make an intelligent decision on the use of the transcript, and at the same time counter-designate portions for the arbitrator.
I think you're being overly optimistic in seeing that happen, however.
Yeah, what's really going to happen is they're going to walk into the arbitration hearing without having designated, and the arbitrator will object, and everybody will say, I'll give you my designations in 2 or 3 days. That's what really happens. All right, the next category, or the last category of evidence that you'll usually present is witnesses. And as you can see from everything I've said now, the witnesses in an arbitration proceeding might very well be the least important portion of your presentation. If you've done your job properly, and if you've really adopted the philosophy of economical litigation, likely your witness presentations will be extremely limited, and a heck of a lot more limited than the use at trial. In presenting witness testimony to an arbitrator, it's similar to a trial. You should be short and sweet and concise and direct. You should prepare your witnesses so that the testimony comes out in the fashion that's both truthful and in the manner which you think is helpful to your case. A difference between a witness presentation in an arbitration as opposed to a court is that it is far less likely that the arbitrator will ask questions of your witness. Judges usually do, arbitrators usually don't. Keep that in mind as you prepare your scope of examination. Also, an important difference, as I mentioned before, there's no record kept, there's no transcript. So not only does that mean you have to be accurate as you move along because you have no ability to refer back, you should be as sweet and simple as possible because there'll be no written transcript for the arbitrator to refer to. What the arbitrator hears will be the total record that goes before the arbitrator in the decision process. Avoid dramatics. I've seen it happen. It doesn't work.
But don't forget, in underlying all of this, is that you still have a plaintiff that's an honest-to-God living person. It's not a stock brokerage firm, or it's not a giant corporation.
Well, maybe.
So
if he's living, again, I thought living plaintiffs weren't the best.
But try and don't forget to personalize this. I mean, you haven't got just a cipher sitting there. You want to make the arbitrator think that this is a people, and so don't just run through your plaintiff's case hi-ho silver. Try and make them come to life a little bit.
Also, I think whatever kind of a case you have, whether you're representing plaintiffs or defendants, and whether it's personal injury, non-personal injury, whatever, and despite the relative informality of this kind of proceeding, both in terms of surroundings and in terms of conduct of the proceeding, for most cases, this is going to be the end of the line. And the result that's achieved is going to be as a result of what happens at this hearing. And you're there as an advocate, and that's what you should be doing.
Cross-examination, it's more difficult in an arbitration proceeding because there is no transcript. It's difficult. You don't get dailies like you would in a complex civil litigation, so you don't have the ability to review a written record of what the witness testified to. The importance of taking good notes from a cross-examination point of view is underscored. You really do have to take good notes. Keep in mind that the arbitrator is less likely to invoke technical rules than will be a judge. This is simply human nature. Arbitrators are doing this as a sideline, not as a main job. So maybe you'll get a little bit more latitude, a little bit more of a ability to get away with stuff cross-examining. But again, it's late in the day, and again, the arbitrators know all the tricks because the arbitrators are trial lawyers. I think, therefore, you have to temper what you're doing with some good old nuts and bolts understandings of how arbitrators really think. And the way they think is they don't like jerks, so don't be a jerk. All right, another category of evidence that's possible to present in an arbitration proceeding is a site examination, a site or object examination. Rule of Court 1614.9 specifically says that you can get the arbitrator to go out and look at something. I think it's more likely that the arbitrator will do that than the judge will do that. It's kind of an interesting break for the arbitrator. The opportunities of arranging for an appropriate time to do so are greater with an arbitrator, and so therefore keep in mind that if an accident scene or a machine that's not working properly or whatever that can't be brought into the arbitrator's office is appropriate, you can go out and show it to the arbitrator. Closing arguments. I think you should make a closing argument to the arbitrator if you're not asked